Okay, let's unpack this. Imagine a country, right, where all the key parts of its transport system, I mean, the busy ports, the airports, the big road networks, even the railways, they're all run under one single set of economic rules. Well, that's not just an idea anymore. It's what South Africa is aiming for with this really significant piece of legislation. It was signed into law back on June 6, 2024. Today, we're doing a deep dive into the Economic Regulation of Transport Act, Act 6 of 2024. And this isn't just, another regulation. It's a huge consolidation, a real merging of policy and oversight that's going to change how the country moves. It officially kicks off mostly on April 1st, 2025.
Yeah, and our mission today really is to demystify this act for you. Doesn't matter if you're just curious about how things work or maybe you're studying law. We want to cut through the jargon. We'll look at its main purpose, the key bits, how it changes the legal setup, and crucially, what it means in practice for businesses, for you as a consumer. The goal is you'll get what it says and why it actually matters. Connect the dots,
Right.
between the legal text and real life.
Okay, so at its core then, it's not just rules for rules' sake. It's about a vision for South Africa. What's the big idea behind pulling all these different transport bits under one roof now?
Well, that's what's really interesting. It's got several layers. The Act itself says it aims to promote a transport sector that's competitive, efficient, and viable. That's key for economic growth, right? And it wants an integrated system covering passengers, goods, across air, sea, road, rail, moving away from that old fragmented way of doing things.
Fragmented, yeah.
Exactly, to boost efficiency, reliability, safety, performance, getting things up to international standards, but also looking at local needs, even things like climate change. It's also about setting up the right institutions, making things more transparent, and, this is vital, encouraging investment in infrastructure. We need that.
And it's not just the big picture stuff, the economics, is it?
Yeah.
I noticed there's a social angle, too.
Absolutely. That's a really important point. The Act explicitly mentions promoting SMEs, small and medium businesses, and also advancing people or groups who've been historically disadvantaged by unfair discrimination in transport.
How does that work in practice? Using economic rules for social equity?
Well, think about it like this. The regulator could, for example, set conditions in transport contracts that give preference to SMEs. Or maybe ensure that when new infrastructure gets built, there are specific targets for training and hiring people from disadvantaged backgrounds. It's about using those economic tools to build a fairer system, not just a faster one.
That's quite a goal.
Yeah.
So who exactly does this act cover? Is it just government stuff or?
Good question. Initially, it applies to any transport market, entity, or facility that was already being economically regulated by the minister right before this act starts. But here's where it gets really interesting. The minister, after talking with the new regulator, can actually declare that the act applies to other players, even private companies.
Oh, really? Under what circumstances?
Well, there are specific triggers. Like if one single operator controls more than, say, 70% of a market. That's significant dominance.
A near monopoly.
Pretty much. Or if the market just isn't working efficiently. Maybe one company has too much power. Or a facility is what they call an essential facility, something critical that can't easily be duplicated, like a key port terminal or a specific rail line.
So it's a tool to tackle situations where there isn't fair competition.
Precisely. But the level of regulation has to be proportionate. You don't bring out the heavy artillery unless it's needed. And there's another big piece here. The minister can also merge other existing regulators into this new Transport Economic Regulator. Think about the Cross-Border Road Transport Agency, the Air Service Licensing Councils.
Wow, so bringing them all under one umbrella?
Exactly. It's a massive streamlining effort that's going to really change the oversight landscape in South Africa. Big implications.
That really is a transformation. Okay, So we have this big vision. But who's actually going to run the show? Who are the new guardians? Let's talk about these new institutions. First up, the Transport Economic Regulator, the TER. When do they start and what's their main job?
Right, the TER. It officially comes into existence on April 1st, 2025. You can think of them as the main watchdog for the economic side of transport. It's set up as an independent juristic person. That just means it's a legal entity like a company. It can make contracts, own property, sue people, be sued. It has its own legal standing.
And its functions. What will it actually do?
A lot. It'll handle the economic regulation, making sure it lines up with national strategy. It oversees transport facilities and services to make sure they're adequate and efficient. It's meant to boost efficiency by encouraging competition. It ensures fair access, promotes investment, does market research, can launch inquiries into how markets are working.
And the big one, prices.
Yes, absolutely crucial. The tier determines price controls for transport. We'll definitely dig into that more. And of course, it monitors if everyone's following the rule and investigates complaints.
So they're not just sitting back waiting for problems. They're actively involved in shaping how things work.
Exactly right. They can develop codes of practice for the industry. They can even push for changes to laws and regulations by advising the minister. So yeah, very much a dynamic, proactive body, shaping the future, not just policing the present.
That does sound like a powerful entity, which raises the question of checks and balances. How do we ensure the tier uses its power wisely? Does that bring us to the other new body, the Transport Economic Council?
Spot on. That's where the Transport Economic Council, or TEC, fits in. It gets established a year after the regulator on April 1st, 2026. Also an independent legal body.
And its role? Is it like an overseer for the overseer?
Primarily, yes. It acts mainly as an appeals body. So if you're a company being regulated, or maybe even a member of the public, and you think the regulator made a wrong decision,
Like on a price increase or denying access to a railway line.
exactly those kinds of things, you can appeal that decision to the council. The TEC also looks at complaints referred directly from the regulator and reviews agreements. It's that essential second look, ensuring fairness and proper process.
So the council provides that crucial check on the regulator's power.
Precisely. And it doesn't stop there. For ultimate accountability, decisions made by the council can themselves be taken on review to the High Court. So there's a clear legal pathway for oversight.
Okay, let's dive into one of the areas that probably affects people most directly. Price regulation. How's the regulator going to set prices? What does this actually mean for the cost of using ports or airports or tolls?
Yeah, this is fundamental. Basically, any entity that falls under the Act's regulation will have its prices controlled. Section 11 lays this out. The regulator has a few ways to do this. They could set specific tariffs, charges, fees, or tolls. Or they could put a cap on the total revenue a company can make from regulated activities.
A revenue cap.
Yes. Or they could limit the rate of return the company gets on its assets. Or maybe use a mix of these methods. It gives them flexibility depending on the situation.
Okay, but how do they decide what's fair? It's a tricky balance, right? Between keeping costs down for users and allowing companies to invest and operate properly.
Absolutely. When the regulator looks at a price control proposal, they have to consult widely. They talk to interested parties, the public, and they consider a whole list of factors. Things like, how efficient is the company? Is it run well? What investment is needed to keep things secure and reliable? What's the cost of capital borrowing money compared to similar risks?
And the wider impact.
Yes, very important. What's the likely effect on the overall economy? On jobs? On consumers?
Right.
On those small and medium businesses we talked about? They even look at whether the operator benefits from past government investment. It's meant to be a really thorough assessment.
That does sound comprehensive. But, things change. What happens if, say, fuel costs suddenly skyrocket or a new technology completely changes the game after a price has been set?
Good point. That's where Section 12, the extraordinary review, comes into play. If there are major unforeseen changes, economic shifts, input cost shocks, new tech that genuinely threaten a company's ability to operate sustainably under the current price controls.
They can ask for an early review.
Exactly. The regulator can step in and conduct an early review. It builds in some adaptability so the system isn't too rigid in a world that, let's face it, changes pretty fast.
Okay, that makes sense. Now let's shift gears a bit. We talked about prices. Let's talk about rail. It's such a critical piece of infrastructure in South Africa, and there's been a lot of talk about opening it up. How does this act tackle rail access?
This is potentially transformative for rail, definitely. Once Chapter 2 of the Act is proclaimed, and note, this specific chapter might not start on April 1st, 2025. It needs a separate proclamation.
Right.
Once it's active for rail, the regulator will determine the cost of accessing rail infrastructure. That's a huge step towards competition. The Act details different kinds of access requests. You might want to run your own trains on the network, or maybe physically connect your private siding to the main line. Or even if the infrastructure owner isn't willing, you could offer to invest yourself to increase capacity.
So you have to try and negotiate first.
Yes, that's the first step. The Act says access seekers must try to negotiate in good faith with the infrastructure owner. If that doesn't work out, either side can then take the issue to the regulator.
And what does the regulator look at then?
They consider things like, Is there enough capacity on the line? Does the access seeker have the financial and technical chops to operate safely and reliably? Do they have other necessary licenses? Interestingly, the regulator can even reassign capacity that's allocated but not being used to make the whole system more efficient.
So if I run a logistics company and I want to start my own freight service on rail, this act gives me a process to potentially make that happen.
It aims to, yes. It sets up a framework for fair access. It creates a pathway. And crucially, the regulator can even grant you access if you agree to fund the necessary upgrades to the infrastructure should the owner not be willing or able.
That could really encourage private investment, couldn't it?
Absolutely. It shifts from what might have felt like a closed shop towards a more open, regulated model. It could unlock huge potential in the rail sector, which is so important for moving goods efficiently.
Okay, rules are one thing, but making sure people stick to them is another. How does the regulator enforce all this? What teeth does it actually have?
Yeah, enforcement is key. The Act gives the regulator pretty solid tools. First, transparency. Regulated companies have to provide data statistics, demand forecasts, their development plans. They also have to follow specific accounting and disclosure rules set by the regulator. So, opening up the books, essentially.
And complaints. What if I feel a port operator is treating me unfairly?
Anyone can file a complaint with the regulator. It could be about being unreasonably refused a license, or facing an unfair decision, or not getting non-discriminatory access, or maybe a company is favoring its own operations over yours, failing to meet service standards, or engaging in what the Act calls prohibited conduct, like breaking the rules of the Act itself, or charging you more than the set price control allows.
And what happens after a complaint?
The regulator investigates. And depending on what they find, they have options. They can issue a compliance notice telling the company what it needs to do and potentially imposing penalties. They could negotiate a consent order where the company agrees to certain actions. Or if there's been non-compliance or prohibited conduct, they can actually order a reduction in the price control.
Really? Cut their allowed prices?
Yes, though there are limits. A price reduction can't be more than 10% of the company's annual regulated turnover, for instance. But it's a real consequence.
And for serious stuff?
For serious enforcement, Chapter 5 kicks in. The regulator gets inspectors and investigators. These officials have significant powers, kind of like peace officers. They can issue subpoenas to compel people to provide information or testify. They can obtain warrants to search premises.
So real investigative powers.
Definitely. And obstructing them, or giving false information, that carries hefty penalties, potentially big fines, or even prison time up to 5 years. So yeah, the Act has teeth.
We mentioned consolidation earlier. This act doesn't just create new things. It changes existing laws quite a bit, right? What gets amended or replaced?
That's right. It's a major tidy-up. Schedule 1 lists the consequential amendments. It makes changes to several other key transport laws to bring them in line. For example, the National Ports Act, the old ports regulator, that body is repealed. Its functions, like overseeing port tariffs, are transferred directly to the new Transport Economic Regulator.
So the tier takes over ports regulation entirely.
Correct. Same sort of thing with the Airports Company Act and the Air Traffic and Navigation Services Company Act. The power to set airport charges and air traffic service fees. That now falls under the tiers price control system, replacing the old ways of doing it. It also clarifies the regulator's role regarding toll roads and user charges under the National Land Transport Act and the SANRAL Act.
And what happens during the changeover? Existing price agreements, staff.
That's covered by the transitional provisions in Schedule 2. Basically, existing tariffs and agreements stay in place until the new regulator sets new price controls under this act. It ensures continuity, and importantly, the staff and assets of the old ports regulator, they get transferred over to the new tier, so that expertise isn't lost.
So it really is a massive shift, moving from several different bodies and rule sets to one main economic regulator for transport. It sounds like it could simplify things dramatically.
That's the core idea, yes. To create a more harmonized, efficient system, cut down on the red tape, hopefully. Create a level playing field across ports, rail, roads, airports. It's a huge undertaking, make no mistake. But the goal is greater coherence, clearer accountability, and ultimately a better functioning transport sector, which is just vital for the whole economy. Centralizing that economic oversight is the key strategy here.
Okay, let's bring it home for the listener. Whether you run a logistics business, you commute every day, maybe you're that law student trying to get your head around administrative law. What are the direct practical takeaways from this deep dive? Why should you pay attention to this act?
You should definitely care, because this touches quite a few things that matter day to day. First, the cost of transport. These regulated prices, tariffs, tolls, they directly impact how much it costs to move goods or people.
Right, the price you pay.
Exactly. Then there's service quality. The Act includes monitoring service standards, so potentially more reliable trains, maybe better port efficiency. We'll see. Competition is another big one, especially in areas like rail access. More competition could mean more choices for you, maybe better services, potentially lower prices down the line.
Yeah, for the economy overall.
A clear, stable regulatory framework like this is meant to provide investment certainty. That encourages companies to put money into building and upgrading essential infrastructure ports, rail lines, roads. That benefits everyone in the long run. And finally, accountability. Stronger complaint systems, an appeals process. It gives you more recourse if you feel you've been treated unfairly by a transport operator. And for law students, wow, this is a gold mine. A live case study in admin law, economic regulation, how you reform major institutions, loads to unpack there.
So we've taken a pretty deep dive today into South Africa's Economic Regulation of Transport Act 6 of 2024. We've looked at its big goals, creating this integrated, transparent, competitive transport sector. We've talked about the new players, the powerful Transport Economic Regulator and the Transport Economic Council. And we've dug into the mechanics, price controls, rail access, how rules will be enforced. It really is a blueprint for unifying the economic oversight of a sector that, literally drives the economy.
It absolutely is. It's a bold move, this centralization of economic oversight for transport. But looking forward, perhaps the big question we should all keep in mind is this. How will this new consolidated framework strike the right balance? The balance between, on the one hand, strong regulation and protecting consumers, and on the other, fostering the innovation and attracting the huge private investment that's absolutely essential to keep South Africa's transport systems growing and modernizing for the future. That's the tightrope they'll have to walk.